South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.
The Global Lawyers Summit, organized by the South Asia Committee of the International Law Section in partnership with CNBC TV 18, brought together industry leaders, experts, and professionals to facilitate meaningful dialogues on the ever-evolving legal landscape. The Honorable Vice President of India, Shri Jagdeep Dhankar, graced the event as the chief guest for the two-day summit. He mesmerized the gathering with some interesting anecdotes and inspirational words. Following the Vice President's address, Pratibha Jain, the chairperson of ABS South Asia and head of Strategy and Group General Counsel of Everstone Group, gave a special address.
My address will be primarily for young professionals. For reasons I can't figure out, for me, law firms were like Lutyens Delhi. They were impregnable. I could never pierce them. I came to know law firms' strength only from the other side when I faced their lawyers in the court. There may be some exceptions. They engaged me because others were not available or not prepared to go to a far distant place. Now, my young friends, learn your lessons hard. My tryst with legal profession, the jealous mistress, started in 1979. In less than 10 and a half years, I was designated senior advocate. The tryst ended. The painful parting took place in 2019 when I was nominated according to Mamta ji, appointed according to the Constitution by the Honorable President to be Governor of the State of West Bengal. So technically, and in legal sense, I am no longer a fraternal member of this august profession. But then, my connect will there be always. That is the reason why I am here. While I am extremely proud of our judicial institutions, we will have to also take care that institution of high courts is fundamental to judicial governance. It is high court that has power of superintendence over subordinate judiciary. That's a big change. All you have to do it.
First, this conference is a conference that brings together the public law aspects of dispute resolution and adjudication and the private law dimensions of business and corporate sector. It is only befitting that the Chief Justice of India was present last year for this and will be giving the valedictory address this year. Of course, we are also very fortunate to have the distinguished presence of Honorable Vice President of India as the chief guest. We are also fortunate that many sitting and former High Court and Supreme Court judges are participating in this conference. Second, this is the only platform I know where the top managing partners of the top Indian firms come together under one roof. Apart from ensuring I get billing discount at one place from all of them, it's an amazing opportunity to learn from their collective wisdom. We have 2 sessions today and tomorrow where they will talk about their journey till date and the future of the legal profession. Third, 6 of the premier law firms of the country have decided to come together and formally commit to create an Indian law firms pro bono club, including AZB, K-Law, JSA, Saraf & Partners, SNR Associates, NDA, and Trilegal. In 2020, sir, I created a foundation called We for Her Foundation that works on women empowerment and access to legal help. I'm happy to inform that 4 premier law firms, AZB, Khetan, NDA, and Trilegal, have already agreed to provide pro bono legal service for this cause. A huge round of applause for all these law firms, gentlemen and ladies.
Another highlight of the event was a power-packed session titled Role of the Judiciary and the Rule of Law in Advancing Economic Development.
But just to give you a context to the panel, I think it's only fair to say that around the world, and of course in India too, Indian judiciary has been among the most respected institutions, not only because of its extraordinary role in shaping India's democracy for over 75 years, but also focusing on issues relating to rule of law and access to justice. Let me start with Justice Seema Kohli. Ma'am, is it fair to say that since the opening up of the Indian economy in 1990s, all institutions have been reshaping and reimagining their purpose, their vision, and indeed the impact?
The opinion of the court was that the economic analysis of law ought to be broadly accepted in India and serve as a guide to statutory interpretation. What would that mean in real terms? It would mean that the Supreme Court must serve as a pivotal affirmation of the judiciary's role in fostering the state's economic growth, of enhancing the well-being of its people within the constitutional framework. So we remain within the structure and we interpret it in a manner that shows that there is a definitive interpretation of the nation's economic prosperity, which is of prime consideration, of its citizens' welfare. And that is also integral, all of it within the framework of interpreting the Constitution by the judiciary.
So the role of G20 has been brought to limelight more recently. To what extent Indian courts use experiences from other jurisdictions, both in influencing and impacting economic decisions? Because, you know, within the G20, there are very developed countries and there are developing countries, and clearly the balance needs to be struck between those two issues when judges are deciding cases.
People have been coming from all across the world, and they are fully appreciative of how we are functioning. And let us not forget, 140 crore people and more than 10,000, 15,000 judges in the country at the level of district level and thereunder, and approximately about 750, 950 judges at the Constitutional Court. So therefore, we are very, the Indian judiciary undoubtedly is very meaningful, very purposeful. And now the world is looking towards us, not only in terms of an opportunity for economic development, but also ensuring that all dispute resolution mechanism is, that India becomes the hub for dispute resolution mechanism. Thank you.
So we have 50 million cases pending in our courts. One of the things that a foreign investor or somebody who is looking from outside coming to India is that they want to see how effective and efficacious the legal system is.
Yes, we know the number of cases pending in our country. We have about 80,000 in the Supreme Court and 61 lakhs in the High Courts and 4.42 crores in the district courts. I think to take out all this, we are using a lot of technology now. It is not that all the cases are delayed. You see, there are good number of cases, about 75 to 80% cases, which are decided within 2 or 3 years of their filing. These are very small number of cases which are delayed in the process. State being a largest litigant, yes, it is said, but if we see the data, in the Supreme Court, the civil litigation is 78%. If you go to the High Courts, it is 72%, and the district courts, it is 25% only, because major chunk is criminal litigation. In criminal litigation, the state has to be party. So we can't universally say that the state is a compulsive litigant, but High Court and Supreme Court, we have seen that.
May I invite Mrs. Hemant Gupta to quickly reflect on the fact that to what extent arbitration and alternative dispute resolution can grow in India, especially to address economic matters.
Somehow or the other in India we have grown with the idea of ad hoc arbitration. Ad hoc arbitration is where the court appoints an arbitrator. And this practice is continuing for last more than 80 years. 1940 Act talked about appointment of an arbitrator by the court, and 1996 also talks about that procedure. You know, the lawyers and to some extent even the judges can't comprehend that institution other than the court can appoint an arbitrator. To be honest, I was Chief Justice of 2 courts. I exercised the power of the Chief Justice as a delegated judge. I had no idea that institutional arbitration is also a concept. This came to my mind only when I started working as a chairperson of this institute.
So most of the time when it comes to economic decision making, somehow environmental issues are put up front as if they are at loggerheads with each other. Having served at the NGT and the Supreme Court, how do you think we should navigate this conundrum?
There is no conflict between development on economic means and the protection of environment. It's a misunderstanding. Once you talk of development, then you must talk of sustainable development. When you are doing unsustainable development, reckless development, destruction of natural resources, you can't call it as development. So once you call the development in its true meaning as it is understood by virtue of law, I am not understanding on individualistic basis, then there is no question of any conflict. Please kindly examine 2 doctrines together, doctrine of public trust and doctrine of distribution of state largesse. Both of them apparently look to be in conflict, but if they cannot be, because they have to be applied in a very congenial and a meritorious manner.
South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.
The South Asia Committee of the International Law Section hosted the Global Lawyers Summit in partnership with CNBC TV 18, providing a platform for dialogue and cross-pollination of ideas along unrivaled networking opportunities for delegates and speakers attending the 2-day summit. A key highlight of the event was a power-packed discussion titled Navigating India's New Personal Data Protection Frameworks, which began with a special address by Honorable Justice Sanjay Kishan Kaul, former judge of the Supreme Court of India.
In this data-driven age, which we had never grown up with, and we saw towards especially the COVID period and the post-COVID period when the judiciary faced these challenges, the sheer volume of personal data collected and analyzed is unprecedented in human history. I was never a member of the Facebook, never a member of anything, till my children told me that you are on the Facebook because somewhere I may have written something and, it is reported so. So the digital footprints we leave behind without sometimes being even a party to it ranges from both our browsing habits, social media activity, more sensitive information like location data, health records, and financial transactions. This generation now is growing up with technology. And I really want to flag the issue for the sake that I think though technology, AI, all these are very important issues, the human race faces many challenges out of it. And these are challenges of mind which is going to take place. And how we deal with it, how we control with them, how the data regime will deal with it is going to be a very important issue.
I would like to start with Mr. Maheshwari, who spent about 35 years with Mehdi. The Data Protection Act, which has been introduced, is largely the foundational basis, and the guiding principles of our law is similar to the other privacy legislations like the GDPR. And Justice Kaul pointed out those lawful bases, which are which is data minimization, storage limitation, lawfulness, fairness, and transparency. But though our law has been based on the same foundational principles, there is a different, unique approach which India has taken. So I would love to get clarity from you that what is the unique approach that India has taken, which differentiates our law from other legislations like the GDPR, and what is the thought process behind this deviation?
As far as India is concerned, definitely at one end, there is a requirement to meet the rights which have been given to the person, to the individual, which is the right to privacy. And simultaneously, we being a growing economy, we doing a good role in a digital world, that this industry should also continue to grow. So maintaining a balance between what the rights of the individual is vis-a-vis the ability of the industry, the ability of the government also, because the law equally applies to the government organizations unless the same have been specifically exempted under the law.
Now over to Damini. So Damini, how are the banks assessing the potential impact of this legislation? Do you anticipate any specific areas of concern or significant changes to your current data handling practices?
The right of information, that one right that they have now, they can come and seek information on what data of theirs is with the data fiduciary, how is it being processed, and with whom is it being shared. It's a codified right, and therefore now if there is a data principal who comes and asks for that information, that will need to be responded. To get to that, you have to have a very clear data architecture on how the data is flowing in, flowing out, and what is being done with the data.
Yeah, thank you, Damini. Over to Adhiraj, similar question. See, as a technology platform which competes on a global basis that processes a considerable amount of data and shares personal data with several third parties, which can include your hotels and airlines, and since you've already made a lot of effort in complying with the GDPR and the CCPA, what challenges do you anticipate in complying with the Indian DPDPA?
I think the challenge will be in how the Indian regulator looks at it, how much time it affords companies to implement this, and as rightly already put, what are the sort of penalties that get applied on companies, at least in the commencement, because the process and the paths to full compliance is not easy, and personally, I'm not aware of any company in the world which can today stand up and say they are fully compliant with any privacy law.
Kicking off the next session titled Lessons from PE and M&A Deals in India was a special address by Honorable Justice Jasmeet Singh, Judge in the Delhi High Court.
In a globalized world where businesses transcend geographical boundaries, it becomes imperative to have strong mechanisms for dispute resolution, especially in the complex domain of mergers and acquisitions. India's involvement in M&A activities had a remarkable start this year, jumping 78% in deal value, reaching to $6.3 billion. As companies seek to expand their reach and consolidate their market position through strategic mergers and acquisitions, they inevitably encounter a host of potential disputes and challenges, including pre-closing disputes, post-closing disputes such as price adjustments, indemnification, many of which span multiple jurisdictions. The same is also true for the multifaceted landscape of shareholders' disputes, particularly from the perspective of Indian law, ranging from breaches, representation, warranties to disagreements over valuation, earn-out provisions, exit rights of investors, and mismanagement. These disputes, if left unaddressed, can potentially derail the harmony and progress of a company, affecting not only its stakeholders, but also the broader economy.
What on this panel we are going to do is share the goof-ups or the issues that had come on M&A deals. And, we are going to share about 10 to 15 examples and live, real-life case studies, with all of you, so that when you are working on deals, you don't have to go through the same issues again. I would love to hear from you, Ria. Anything based on your experience on due diligence?
I think when you have compliance issues of this nature, you do need to look at sort of all facets of how this impacts, legal, tax, financial, commercial. Because I think if these kind of non-compliant activities, you are getting a target company to stop it. And this will be quite prevalent in developing markets and growing economies. Then there could be a potential impact on the business or on the, profits of the company even.
Yeah, it's a tough balancing act. Yeah. Moksha, you want to go next?
The two issues that I have seen lately, which are interesting, was one, a private equity fund which was trying to sell out of an investment, and they instructed us, we need to do a diligence and we need to move on and find buyers. when we looked at their shareholders agreement, we realized that the confidentiality provision there actually did not let them share information with a third party. And that happens more often than it actually should, which is that because there are templates that have been negotiated in the past, somebody's not thought through things. I mean, obviously, if it's a significant or a sophisticated enough investor, these sorts of things get picked up, but sometimes they don't. So that was one issue that I had.
In fact, it's always said a good document can never replace a bad promoter, and a bad document can, still take care of a good promoter. So Shobita, you want to go next?
My example is actually one where the deal went through. This was almost 20 years ago, and it's an example that I still think about, though. We were acting for a private equity fund that was doing 100% acquisition of an automotive parts manufacturer. And diligence was done, documents were executed, deal went through. There was a holdback, and we were sort of waiting to hear back from our investor client as to whether there'd be any claims under the holdback. And about 12 months after the acquisition, the client came back to us, and their concern was that in the running of the company, they had noticed that the revenues of the company were not sort of aligned to the projections and what they had assumed when the company was valued. And it's a lesson that diligence doesn't end at any point in time. That disclosure should have been discussed more. The implications of that should have been looked at by the deal team much more. And I'm very sure that it would have impacted valuation if that was done. But for whatever reason, it didn't happen. And so now we read the disclosure letter 500 times because you want to make sure that there are no such surprises in there.
The cases were sometimes so heinous that you can't even assess, and normally a deal lead time is easily 6 months, 5 to 6 months. You're spending time with that person day in, day out. You can't even believe that you could have been involved in violence, having, some weapons at home and whatnot, and you're like, such an aggressive guy. How can you do that? So, these kind of examples actually, create a trouble.
Okay, looks like I think we have done a good job. Thank you, and thanks to all the panelists for sharing your insights. Thank you.
South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.